This is the fourth in a series of videos about representing yourself in a court for a civil law matter. It's like taking a flight somewhere. Videos 1 and 2 are about getting your tickets written. Video 3 is all about sorting out your luggage. And this video is all about your arrival at the destination, a court hearing. Many civil law matters include more than one court hearing. There may be hearings along the way, called interlocutory hearings, so the court can make orders to keep the matter on track, as well as the final hearing or trial. For all of these types of hearings, you need to prepare documents and arguments, as well as know your way around the court itself. That's what this video is about. So strap yourself in, because you are about to land. To prepare for your arrival at any court hearing, you need to complete some arrival documents. These are called your submissions or outline of argument. They are your legal argument about why the evidence you have given the court supports you getting the orders you have asked for, or does not support the other side getting the order they have asked for. Your argument should normally be short and to the point. You can't make an argument if you don't have evidence, and you can't introduce any new evidence that you haven't disclosed. As we explained in video 1, the court must apply the law. Your job is to show the court that the law is in your favour. Different courts have different rules for preparing and sharing submissions. Check the website of the court your matter is in to see if there are any practice directions about this, or see our volunteer lawyers. Generally, written submissions are organised around these questions. What is the hearing about? What are the key background facts that are relevant? What issues are still in dispute? You may like to go back and see video 3 for more on this. What does the law say? This includes any legislation or relevant cases decided by the court. And what court orders do you want? Preparing written submissions helps you organise and focus on your key points, and take some of the stress away from trying to remember all of your arguments. Now you have your submissions ready, there's still quite a bit to do before you get into the actual courtroom. It's a bit like going through customs, which, as you know, can be frustrating. Our top 10 tips for getting through these are on the fact sheets. These are all about staying calm and organised. We also recommend these video courtroom tours, which have some more tips and will help you get more familiar with the court. So now you've arrived at the court on the day of your hearing. This one is an interlocutory hearing to see if everyone is organised.
Are you Paul?
Yes.
Hi, I'm Christy Grogan, Deane's solicitor. How are you?
I'm good, thanks. How are you?
Not too bad, thanks. I've prepared some draft short minutes of order that I'd like you to take a look at. They basically set out a timetable going forward in the proceedings, and I just want you to read them and see if you agree with them.
Lawyers often talk to each other before hearings to see if they can agree on what the next step should be. This helps the judge and the court get things done quickly. Be polite to the other side's lawyer and listen to what they say, and expect the same courtesy in return. If you don't agree to something or don't understand, make sure you are reasonable. Otherwise, you may have a cost order made against you.
Let me see. I would like more time to get these documents listed in number 3 together. Could we push this date back, say, 2 weeks?
I think that should be fine.
All right. Everything else looks like what I was hoping from today's hearing, so that we're ready for the main trial.
Okay, if you just leave them with me, I'll finalise them, and then we can both sign off on them, and I'll bring them to court and we'll hand them up to the judge today.
Okay, sure.
Great, thank you. Bye.
When you arrive at court for an interlocutory hearing, you may notice the court list has quite a few matters listed at the same time. The court wants everybody to be there, and then it sorts out who will go first by doing a call over to check who is ready. Let's look at a call over in action.
John Smith and Gardens Proprietary Limited.
I'll take the appearances, please.
Speedy, initial M, a solicitor for the plaintiff, Your Honour.
Notice how the lawyers are telling the court their names. Every court hearing is recorded, so this is for the court record. The main thing to remember when introducing yourself to the court is to speak clearly.
Thank you, Mr. Speedy.
Dart, initial J, solicitor for the defendant, Your Honour.
Yes, thank you. Mr. Speedy, I understand you make an application on behalf of your client.
Yes, Your Honour. This is an application for further and better particulars of the defence. I estimate we'll need 30 minutes.
All right, thank you. I'll hear your matter probably around 12 noon. You may both leave the bar table in the meantime.
Thank you, Your Honour.
Thank you.
Paul Peterson and Dina's Car Wash Proprietary Limited.
Please announce your appearances.
As you can see, the judge is having each matter called out, so he can find out what the parties need and how much time it will take, letting the judge plan the court's day.
Your Honour, I'm the plaintiff, Paul Peterson. I'm representing myself.
Yes, thank you.
Grogan, initial K for the defendant, Your Honour.
Ms Grogan, I understand your client seeks leave to file an amended defence and also for further directions.
Yes, Your Honour. My client and the plaintiff have agreed to some consent orders. If I could hand those up, Your Honour.
Yes, thank you.
Never walk up to the judge yourself. You need to stay at the bar table. Ask the judge for permission to give the judge a document. This is called handing up a document. The court bailiff or judge's associate will come and take any documents from you and give them to the judge.
Have you seen those orders, Mr Peterson?
Yes, Your Honour.
Are you happy with those orders?
Yes, Your Honour.
So you consent to them?
Yes, Your Honour.
Very well. In those circumstances, the court orders by consent 1. The defendant is given leave to withdraw her deemed admissions and to file and serve an amended defence by...
Take notes of what the court orders so that you can be sure what your next step is. Some courts will give you a copy of the order. Other courts require you to prepare and file a draft order that is checked against the court's records and then formally issued. Let's imagine that instead of consent orders, the orders weren't agreed on and there was some argument. Now the court has made an order. The court will also ask about costs.
And what about costs, Ms Grogan?
Costs are intended to partially reimburse a party for their legal costs. Usually the party who doesn't succeed in an application has to pay the costs of the party who succeeds.
We would ask that each party bears its own cost of the application, Your Honour.
Mr Peterson, do you have any comments about that?
Well, Your Honour, I've had to come to court today to answer this application and missed a day of work. I'd like costs to compensate me for that.
If you're self-represented, you can't get a costs order to compensate you for your time, but you can ask for any out-of-pocket expenses, such as a filing fee.
Mr Peterson, I'm afraid that the rules of court don't allow me to compensate you for your time, but I can order that each party bear its own costs of this application, and I so order.
Court customs can be tricky, and the rules of evidence and procedure can be challenging. It's important that you understand and comply with these rules. Remember, judges apply those rules equally and fairly to all parties before them, regardless of whether they have legal representation or are self-represented. These rules are particularly important when the matter comes on for trial. The next video will look at some important aspects of the trial.